ask for his participation in the PEP program, along with other San Francisco area sheriffs, in the month of April. And so, as I said, I'm making the rounds with a lot of jurisdictions. My Deputy Secretary and I and other leaders in DHS have been very, very active for the purpose of promoting public safety to get jurisdictions to cooperate with us on this.
Thank you, Mr. Secretary. Thank you, Mr. Chairman.
Thank you. The Chair now recognizes the gentleman from South Carolina, Mr. Gowdy, the Chairman of the Immigration and Border Security Subcommittee, for 5 minutes.
Thank you, Mr. Chairman. I also want to thank the gentleman from Texas for letting me go in his spot. Mr. Secretary, I've been on this committee for almost 5 years now, and I have listened as witnesses primarily called by our colleagues on the other side of the aisle have repeated with almost catatonic frequency certain phrases like citizenship for 11 million aspiring Americans, as if 11 million of any category could all pass a background check. Phrases like functional control of the border. Phrases as benign sounding as sanctuary cities. And I've listened pretty carefully, Mr. Secretary, as I've heard argument after argument after argument made against empowering state and local law enforcement to actually enforce immigration laws. Have you had a chance to look at the criminal history of Mr. Lopez Sanchez?
I believe I have, yes.
It dates back to 1991. The criminal conduct occurred in 5 separate states. He's committed local, state, and federal crimes. He was and is, by any definition, a career criminal. He violated at least 3 separate statutes when he simply picked up the gun before he shot and killed an innocent woman walking with her father. So, to me, Mr. Secretary, he is Exhibit A that we must not have functional control over the border, or he wouldn't have re-entered so many times. And he is, I'm assuming, not able to pass anyone's background check. I would hope that somebody with this criminal history couldn't even pass our friend in the Senate's comprehensive immigration reform background check. Now, I want us to look at a legal issue in a second, Mr. Secretary, but I want to read a quote to you, and I want to ask you if you know who said it. I want people who are living in this country undocumented to come forward, to get on the books and subject themselves to a background check so I can know who they are, and whether it's the current DACA program or a path to citizenship, whether it's deferred action or earned path to citizenship, from a Homeland Security perspective, I want people to come forward. Do you know who said that?
Well, I don't know if I said it or not, but that is consistent with my own sentiments, so I could have said that.
You did say that. Now, I want you to tell me what in Defendant Lopez Sanchez's background leads you to believe that he would, to use your words, come forward.
Well, clearly, he is not the type of person that would ever qualify for any sort of deferred action.
I know that. Nor is he the type of person that would come forward, Mr. Secretary. So my point is, when you have a porous
sentence, sir?
Sir?
May I be allowed to speak?
You are welcome to answer the question that was asked, yes.
Well, give me a chance, please. He is not any kind of person who would qualify for any type of version of deferred action in my book or earned path to citizenship. He is a criminal, a dangerous criminal, multiple times over. When we talk about encouraging people to come forward, what we're talking about are people who we hope will report crime, who will participate in American society fully. Obviously, somebody like this is not coming forward.
No, he is not coming forward, Mr. Secretary. I'll let you answer the question, Mr. Secretary, but I'm not going to let you run out the clock. You're right, he's not coming forward, and he doesn't need to get on the books because he's already been on the books. In fact, better than being on the books, Mr. Secretary, he was in federal prison. So I want to know, why was somebody in federal prison with a federal detainer on him released to a sanctuary city?
You'd have to ask the Bureau of Prisons.
Have you asked the Bureau of Prisons?
We've had a detainer on him, both when he was in BOP custody and when he was in the custody of San Francisco.
I know you did. My question to you is...
I'm quite sure that there are a lot of questions being asked right now. In my book, he is Exhibit A for why jurisdictions need to work with our priority enforcement program. Secure Communities was not working. There were over 12,000 detainers of mine that were not acted upon.
Well, then why don't you make them mandatory, Mr. Secretary?
Working.
Why don't you make the detainers mandatory? If cities like San Francisco are not complying with federal detainers, why don't you make them mandatory?
I think that would be a huge setback in our ability to work with state and local law enforcement, and I suspect they would agree as well.
Well, I do not agree, and I'll tell you why I don't agree, Mr. Secretary. What I find ironic is you are not willing to mandate federal detainers, but you are willing to mandate that state and local law enforcement cannot assist you in enforcing immigration laws. I mean, help me understand that. You can empower a city like San Francisco to ignore federal law, but you won't empower state and local law enforcement to actually enforce immigration laws. Help me reconcile that.
Can I speak?
Yes, sir. You can have the rest of the time.
Thank you. Thank you for giving me 7 seconds.
Now, you take all the time you want to answer the question, because I think it's important.
I'm sure you're aware of this. The Secure Communities program was hugely problematic in the courts. The courts were saying that state and local law enforcement does not have the authority under the Due Process Clause of the Constitution to hold people until we could come and get them. Last time I looked, through federal legislation, you cannot rewrite the Due Process Clause of the Constitution. So that is a problem. I do not believe that mandating through federal legislation the conduct of sheriffs and police chiefs is the way to go. I think it will be hugely controversial. I think it will have problems with the Constitution. I want to see us work cooperatively with state and local law enforcement, and I believe that they are poised to do that.
Well, my time is up, Mr. Secretary. The last time I looked, we had a supremacy clause. And federal law trumps state law, so God knows it trumps the law in San Francisco. And when I hear the phrase sanctuary city, as benign sounding as it is, it may have been a sanctuary for that defendant, but it sure as hell was not a sanctuary for a young woman walking with her father. So at a minimum, change the name of whatever benign-sounding program cities like San Francisco want to follow, and the money ought to be cut, and I would hope that you would insist that federal detainers be honored and not be discretionary. And with that, I would yield back to the chairman.
Chair thanks the gentleman and recognize the gentleman from New York, Mr. Nadler, for 5 minutes.
Mr. Chairman, first, I want to welcome Secretary Johnson. And as the former chairman of the Constitution Subcommittee, I'd like to remind Mr. Gowdy that the Supremacy Clause does not trump the Fourth Amendment, and that the federal courts have held detainers unconstitutional as violations of the Fourth Amendment. So when Secretary Johnson said there were troubles in the courts, there were indeed troubles in the courts. And I want to commend the administration for trying to follow a policy that is not unconstitutional and illegal on its face, as the prior policy was. Now, Secretary Johnson, I have heard significant concerns about mistaken and even fraudulent issuance. I realize this is off the one topic we're supposed to talk about, of O-1B and O-2 visas to aliens coming to the U.S. to work in the motion picture industry. Movie and TV production jobs provide the livelihood for a great many New Yorkers, so I take very seriously allegations that CIS is improperly allowing unqualified aliens to fill those jobs. I'd like your agency to take a serious look at these assertions or allegations. Would you commit to working with me on this issue?
Yes.
Thank you. On an allied topic, we have been asked, and I've looked at it sympathetically, frankly, to increase the number of H-1B visas. And in fact, we voted out of this committee an increase of 50,000 H-1B visas, which most of us on our side of the aisle voted against only because of the provision to eliminate an equivalent number of diversity visas. But the assertion that we need more H-1B visas because we have to bring engineers and others to this country that to fill positions that we can't fill here, we've heard that repeatedly. And yet, we see these recent stories about the Disney company and others laying off hundreds of their own American employees who were then forced to train foreigners who came here on H-1B visas to replace them. Now, if that is true, there's a very serious failing of the H-1B program, and it being used to displace American workers rather than to supply people for slots that American workers can't fill. Is the department looking into that as to how that program is being abused, and can it be fixed properly?
Through the H-1B program, those who hold the visas are not supposed to replace Americans with the jobs, as you know, as you pointed out. any such allegations are very troubling to me. I believe that such matters should be investigated. I also believe that Congress can help in this regard. I think that Congress can help through increased enforcement mechanisms for situations where an employer does in fact replace American workers with H-1B holders. That is a recommendation that has been made to me, and I support that.
Thank you. Mr. Secretary, the United States has a long-standing commitment to refugee protection, and we pride ourselves in our open and welcoming refugee and asylum laws. I understand that these laws need to be balanced with legitimate border security initiatives, obviously, but I'm concerned that in our quest to expedite the removal of individuals from our country, we may be deporting those with serious persecution claims. Recently, DHS instituted a pilot program expediting the deportation of Central Americans beyond the normal expedited removal process. These detainees are apprehended by CBP and then detained by ICE away from the general population. They are not given any Know Your Rights presentations or access to attorneys and are deported within a matter of days. Advocates on the ground are being told that these detainees are being held in facilities, particularly in the Port Isabel Detention Center and other facilities in South Texas. I'm also concerned that we may have transferred our burden of border security to the Mexican government and that they are summarily deporting Central American refugees without offering them any protection under international law. Under U.S. pressure, Mexico has more than doubled its detention and deportation of Central American children, families and adults over the last year without commensurate resources into identifying and offering protection to legitimate refugees. I find these practices troubling, given that there are several news reports about the horrific violence in the region, especially against women and girls, and articles stating that Central Americans are being killed upon their deportation from Mexico and the United States. I'd like to enter some of these into the record, Mr. Chairman. And
if the gentleman will at some point designate which ones, we will put them in the record.
Law enforcement involves enforcing those laws that provide protection from persecution too, and we have an obligation to make sure that we don't undermine that at our borders or at our friends' borders. What is the administration doing to ensure that Central Americans' refugees' international protection claims are being honored by both our government, and that is to say that they have an adequate opportunity to make their claims with proper legal assistance, and by the government of Mexico?
Well, a couple of things there, Congressman. First, we have prioritized among our CIS personnel interviews of people on the border, particularly from Central America, who may have a reasonable fear claim and a credible fear claim. In the most recent guidance I issued, I directed that these interviews be conducted in a reasonable period of time as quickly as possible. My hope is that we can get those done in, on average, around 14 days after apprehension. So that's one thing. When it comes to refugees, the other thing that we have begun, which I'd like to see more use of, is in-country processing in Central America. Advice we got last summer when we were dealing with the spike there is we need to offer people a lawful, safe path to the United States. And so we set up in-country processing, the ability to interview kids in the 3 Central American countries who have parents who are lawfully here to see if they would qualify for refugee status. Frankly, not enough people have taken advantage of the program. It's in the low thousands. I'd like to see more use that method versus trying to make the journey through Mexico, which is very dangerous, and crossing our border illegally. And so we're encouraging people to make use of that program in Central America. And I want to see us publicize it, put emphasis on it, because it is the lawful, safe path to come to the United States.
My time has expired. I yield back. Thank you.
Chair thanks the gentleman and recognizes the gentleman.